In the previous lesson, what we did was talk about the role and nature of human rights and fundamental civil liberties within the confines of the UK's constitutional framework. And we talked at quite a lot of length and in quite a lot of detail about the Human Rights Act and the European Convention on Human Rights, from which those Human Rights Act provisions are drawn. Well, in this lesson, we're going to talk in a bit more detail, firstly about the Human Rights Act, very quickly covering the content of the Human Rights Act. One of the things, or specifically looking at the specific rights that are cited within the Human Rights Act, this could be quite useful if you want to provide just a little bit of extra content, a little bit of extra specific information for an essay question, that you can just throw in an extra line about some of the potential provisions therein. And then we'll talk about other methods of protection of civil liberties and focusing specifically on what is known as the Freedom of Information Act and look at the political implications of the Freedom of Information Act here. So, like I mentioned, the last lesson introduced the subject of civil liberties, looking first at the European Convention on Human Rights, which the UK has been a member of since the 1950s, followed by the passage of the 1998 Human Rights Act. This lesson is going to examine the Human Rights Act in a little bit more detail and then talk a little bit about some other cases under the Human Rights Act, as well as the Freedom of Information Act as well. So let's think about the Human Rights Act in action. Okay, how has it been applied? What has been used to apply the Human Rights Act? What kind of cases have been brought in front of the Human Rights Act? Well, the Human Rights Act itself is made of a number of specific provisions, each of which outlines specific and fundamental freedoms. Now, these are the provisions that encode the specific rights of the Human Rights Act. They're not necessarily the procedural provisions, which relate to things like declarations of incompatibility, etc., etc., etc. So, essentially, the first of the provisions of the Human Rights Act commits all the signatories to protecting the rights which are included in the Convention. And then we have the right to life protection, the prohibition of torture, degrading, or inhuman treatment. We have the outlawing of slavery as well as involuntary servitude. We have the securing of liberty and security of the individual against arbitrary arrest and arbitrary imprisonment. We have the guaranteed right to a fair trial. We have the prevention of legislation which criminalizes acts retrospectively. So the idea behind the idea of retrospective criminalization is this view that we probably shouldn't pass legislation that criminalizes something that was previously not criminalized, and then go back and charge and arrest every single person who once did that act. So if, for example, it became a crime tomorrow to drink coffee, then we shouldn't go back and arrest everybody who used to drink coffee back in the day or today, for example. That's what retrospective criminalization prevents us from doing. Part 8 promotes the respect for individuals' rights to private and family life. We also get the protection of the freedom of thought, consciousness, and religion, freedom of expression, and the right to assembly, the freedom of men and women to marry and start a family, etc., etc., etc. So this is a few of the rights that we have. Now, a lot of these rights, you will know, are drawn from the European Convention. So, for example, Article 6 of the European Convention also guarantees the right to a fair trial. We also have the freedom of expression, the right to assembly. We also have the prohibition of torture and degrading or inhuman treatment. In Article 3 of the European Convention, the right to life exists within the European Convention. So there are similar parallels, but you should remember to note that what was described in the previous case in 2007 by Lord Bingham, this idea that the rights in the Human Rights Act are slightly different to the rights within the European Convention. Because the European Convention applies these rights to international law, specifically onto the state of the United Kingdom, these rights are applied with domestically to the UK itself, because they are legislation passed by Parliament. So just bear that in mind. But again, remember that I did also mention in the previous lesson that that's a technical detail that isn't necessarily too important for an A-level student to have to wrap their head around, or to go off and write a massive essay about the precise and distinct legal delineations between the rights in the Human Rights Act versus the ECHR. You won't get many marks for doing that. So that's just a little bit of extra information in the background. Now, what about the earlier cases under the Human Rights Act? The first of these early cases were the killers, the murderers of James Bulger. So, essentially, one of the earliest cases, one of the most shocking cases within the United Kingdom, at least in recent history, was the kidnapping and murder of the 2-year-old, I believe he was 2 years old, James Bulger, who was kidnapped in a public shopping centre in, I believe it was Manchester, in the 1990s by two older boys, still young boys, but older than Bulger, one being Thompson and Venables. Now, these boys then took Bulger to a train track and murdered James Bulger. It was an incredibly shocking case. Okay, both of the boys were convicted of killing James Bulger in 1993. Now, the case itself sparked a significant amount of fury within the media and within the broader populace at large, and it brought into question the safety of the two perpetrators for this crime, the safety of Thompson and Venables, such that essentially what had happened was the court decided to impose a lifetime ban on their new identities. So they'd served their time in juvenile detention, and then they had been given new identities. They had been able to not be photographed or their images released to the public since their arrest and since their conviction, and they were able to get new identities and live their lives away from the public spotlight. This was done under the human rights justification that they had a right to life under the Human Rights Act, and the actual revealing of their new identities to the public would actually threaten their right to life, given the severe and quite, in some cases, quite hostile opinions towards these two individuals. So that's one of the earliest cases that relates to the Human Rights Act. We also have the treatment of mental patients. A paranoid schizophrenic killer was detained at Broadmoor and argued that the Mental Health Act of 1983 had reversed the burden of proof, which essentially required him to prove that he was cured before he could be released. And that was the question here: is does this burden of proof reversal conflict with the Human Rights Act? And the Court of Appeal ruled that it violated both the Human Rights Act as well as Articles 5 and 6 of the European Convention. The final thing I want to talk about is another piece of legislation which gives rise to certain civil liberties and fundamental freedoms, one of which being the Freedom of Information Act. Now, this was part of New Labour's manifesto in the 1997 general election, and it included explicit commitment to introduce freedom of information legislation. What does this actually entail? Well, the Freedom of Information Act would receive royal assent on the 30th of November 2000. It wouldn't come into force until the 1st of January 2005, and essentially what it did was it gave citizens the right to access information held by public authorities. Not all information, so there was obviously some top secret information that would not be available to be released. But the the Freedom of Information Act essentially allowed individual citizens to gain access to public authorities' information. Now, it required public bodies seeking to deny those requests for information to show that the public interest warrants an exception under the Act. So essentially the burden was on the part of the public authorities to prove that the information should not be released, rather than the burden of proof being on the citizens to prove that it should be released. It's the discretion and the right of any citizen to access any information by public bodies, unless otherwise stated as an exception under the Act by those bodies themselves. Now, for the most part, the Freedom of Information Act has not had the most significant in terms of consequences, or the most significant in terms of insights. Most earlier requests came from individual citizens or media organizations that sought the Act to either clear up loose ends on earlier stories, or to essentially conclude some information that they didn't have originally. In no area, however, that the Freedom of Information Act was more apparent in its use and more substantial in its use was in the case of the MP expenses scandal, where it was revealed by Freedom of Information Act, after Freedom of Information requests, that MPs had been claiming on their expenses a number of different things that were essentially gratuitous or just essentially not within the limits of what ought to be claimed on an MP's expenses. Some of these are going to the eye-watering levels of hundreds and thousands of pounds, and actually causing some individual MPs to go to prison. So that's one of the things that the Freedom of Information Act was very useful in being able to apply. Now, for some of you who are potentially looking to add further to your understanding of human rights, specifically, maybe if you are doing so for the purposes of your A-level politics course, or maybe just because you have a general interest in this, or maybe it could be an extended project that you might want to write a dissertation on at A-level, or if you want to go and do this in the future at university, etc., etc., we have a series of lessons on the Law Academy covering UK human rights law and UK human rights law, specifically the law applicable to the Human Rights Act. It is a undergraduate focused level set of lessons, so it's going to be a lot more technical and a lot more detailed in human rights law than this series of lessons has been. We also have lessons on the European Law Academy that relates to the law relating to the European Convention on Human Rights. Specifically, again, another technical legal approach to the ECHR and the lessons that we have there. And if you really want to, go to the International Law Academy and look at how international human rights law works in more detail, looking at how the UN treaties applies to individual states and some of the internationally recognized human rights that exist. So all of those, I'll put some links in the description down below for you to have a look at those series if you want to have more of an understanding and more detail on this particular subject.